Good evening, everyone. Thank you for joining our live webinar. Today's topic, and with a smiley lady next opposite me, is Riva Lange. But today's topic, mediation and divorce matters. It's our take two. Last week we tried to do this topic, but unfortunately we had some technical difficulties. The stream is perfect. If you're on Facebook Live, you should be able to see us wherever you are, and we're ready to go. So I spoke to Riva a moment ago, and she'll obviously introduce herself shortly. We will be doing a take two, so whatever we discussed last week, we will just repeat, and it will sound like it's the first time we are mentioning it, and we look surprised, and she might say, oh, advocate, that's interesting, although I said it last week. But nonetheless, today's topic, mediation in divorce matters. Please note you're welcome to post questions on the Advocate Mohammed Abduroaf Facebook page, also via Zoom as well, the same Zoom connection me and Riva are on now. You're welcome to join it as well. Unfortunately, your name might appear on your Zoom name on the video, but that's up to you. And of course, you're welcome to pose a question via our various links below. But nonetheless, let me introduce allow her to introduce herself. Riva Lange, an attorney. Riva, please welcome, and please go ahead, tell us about yourself.
Thank you, Mohammed. So as you said, I'm an attorney and a mediator. I've been mediating in the family law field for more than 10 years now. And I'm recently branched out into commercial mediation as well. I'm a passionate believer in mediation as an effective problem-solving method and as a way of parties resolving differences without the expense, both emotional and financial, of running a litigation matter. We're seeing more and more internationally a move away from litigious problem-solving towards more collaborative problem solving, and mediation has been around for a long time and has a very good track record. So I specialize in family law mediation, and commercial mediation.
So if I may this, maybe use a synonym, you get two types of people that fight and people that are there to, to keep the peace. You're more of a pacifist. Let's keep the gloves, off our hands. Let's not go into the fighting in the court. Let us speak it out on a coffee table, and at the end of the day, we'll get exactly the same results. The only difference is with a court matter is the judge forces the result on you. With the mediation matter is you and the other party, you guys come to your own amicable solution. Am I on the same page?
Yes, we're totally on the same page. But I think what also is important to realize is that even those fighters, those are ones who think that they want their day in court, with the right persuasion, can be convinced to sit around a table and to have a mediation. And mediation has very many different forms. I mean, there's a traditional mediation where you have both parties and the mediator around a table together. But there's also other formats. There's the shuttle mediation, where you move between the two parties, which is very effective in disputes where the parties can't actually be in the same room, or where they each require different things. So so in those situations, then a shuttle mediation would work really well. So even highly litigious people sometimes are faced with having to mediate. And as long as there is a willingness to explore possibilities, a willingness to work with each other and the mediator, even if it's a grudging willingness, doesn't have, not all kumbaya moments. As long as there's a willingness to at least participate, then there's a possibility of settlement and of reaching agreement, which is the ultimate aim of a mediation.
Yes, and Riva, on that point, it's very interesting. I done a domestic violence matter yesterday, and this matter was on my desk for the last 6 months. We postponed for trial quite a few times. And it seems to me the reason why we could not resolve this matter was not necessarily because of the issues involved. It was because of the legal representatives on behalf of, I'm not giving myself a pat on the head here, but the legal representatives on the other party side did not advise the clients on the benefits of trying to mediate this matter. It's basically, you go to an attorney or an advocate, they come out with a sword, and the only job here is to fight. That's all we know how to fight. So the same way, if I'm a plumber, or maybe like a bricklayer, and I ask you to fix a door for me, I will use hammers and shovels and stuff like that. But if I'm an electrician to fix a door, I'll use those tools. So it seems to me that we need to start educating legal practitioners, especially litigators, as to the benefits of mediation. That it is a valid alternative dispute resolution mechanism to resolve dispute. They can still make money off their clients, because what generally happens is You represent the client, you use up all their money, at the end of the day you have to withdraw from the matter. But if the parties try to mediate the matter from the start, they could have actually made money, at the same time also resolve the problems. What's your take on that?
No, I agree with you. And I think especially in your more complex commercial matters, attorneys play a very vital role. They play a vital role also in family mediations. In fact, I've been involved in a number of mediations where the attorney sits in, where they are part of the process, because especially if there's a power imbalance between the parties, very often one party will want that security of their attorney sitting next to them. And that's fine. I mean, an experienced mediator can work with that. You know, there are mediators who prefer not to, who say that attorneys don't belong in a mediation. I'm not one of them. I believe that attorneys play a vital role in most matters. And if parties have already sought legal advice and they've already got legal representatives, you have a far greater chance of reaching settlement if you can bring those legal representatives into the mediation process. And you know what attorneys also need to understand is that the mediator is not there in any sort of competitive basis. The mediator is a facilitator. Your mediator is there to assist the parties to facilitate agreement. To do that, there are certain processes that have to go through. But a mediator cannot at any stage after mediation has terminated act for either of the parties going forward. So if the mediation doesn't work, then it doesn't work. So it's not really a threat to the attorneys at all, to be honest. And I think that with the introduction of Rule 41A in the High Court, with court-annexed mediations in the High Court and Madge Court, there is a push back from the judiciary, from the legal profession as a whole, to say, hold on, people, the system is not working. Our courts are oversubscribed. It's taking a very long time for matters to be resolved. You know, urgency is becoming a lot tougher. You know, before attorneys would take their chances. Let's try an urgent, but you know, the judges are pushing back and saying no. Urgent court is there for urgent matters. That's a whole other discussion. But the point is that mediation offers a alternative that can produce as good results as a litigation, if not better, because as you said, in a mediation, the parties themselves are the architects of the solution. You go before a judge, the judge is constrained by what is before him and what the law says. A magistrate is constrained by what is in the papers and what the law says. So being able to think outside the box and being able to be creative is one of the great strengths in mediation.
Now, Riva, that's very interesting what you mentioned now. And if I look at it, without attorneys, mediation could possibly be unsuccessful, because a mediator is not necessarily a legal person, not always a legal person. So he or she might not understand the law and so on. So regarding a domestic violence matter, for example, where one party might believe that if a protection order is made final, or they agree upon a protection order, they might believe that they cannot work overseas, that they will be blacklisted, they will have a criminal record and so on. But that's not necessarily the case. A protection order is a civil issue. It's a issue between you and the other party. It's not something that will block you from getting a police clearance, etc. So they might come to the table with those preconceived views and ideas, as opposed to settling the matter. Or the father might think, you know, if I have an order against me that I should pay maintenance to the minor child, it will block me from applying for work, etc. It doesn't work that way. But so if the attorney explains that to them and tell them, you know, worst case scenario, this would happen. And mediation, if the problem gets resolved by mediation, nothing bad will happen. And it's not necessarily always the job of the mediator to inform the parties of the law and the legal rights, because I think that will be unfair, because she might be seen as taking sides here, because it's not the job. But the job is trying to resolve the issue. So Riva, I like that very much. Riva, before you comment, I want to ask you a few questions quickly.
Sure.
Tell me what we're dealing with the law, we're dealing with the theory here, but the practical problems people would come to in family divorce mediations, what would it be?
So divorce mediation primarily takes the place of a litigation. So the parties are coming to mediate a settlement agreement. And that's going to cover a wide range of areas. It could be that there might not be children involved. There might be older children involved. If there are no children involved, then it might be primarily financial. So the typical issues that need to be resolved. Mohammed, I can't hear you. No problem. I'm not sure where you heard where I left off. So I'm going to start again then. So the matters that can be mediated in a divorce settlement are the same matters that can be mediated in a litigation. So that would be the proprietary consequences of a marriage. So what happens to property? How are the parties married? Is it in community of property, out of community of property, with accrual, without accrual? What's nice about mediation is that within that, there's a greater room for creativity. Okay, then you have issues relating to children. So there might be issues relating to where are the children going to live? Are they going to live with one parent? Are they going to live with both parents? Are they going to, what sort of contact is the other parent going to have? How are the parents going to exercise their parental responsibilities and rights when they're in two homes? Also, there's this issue of maintenance for the children and sometimes maintenance for one of the parties. But over and above that, mediation allows for greater creativity. So there might be other issues. The parties might have issues communicating. So as part of the mediation, you might want to mediate methods of communication. How are we going to communicate with each other? The practicalities of it. What is it going to look like? A well-drafted agreement and a well-drafted parenting plan are really about creating roadmaps for the future. It's about creating a document which the parties can refer to in situations where they get stuck. So you don't want it to be too formalistic. You don't want it to be too rigid. There has to be a certain flexibility, but there needs to be a bottom line. So it's that fine tension between flexibility and certainty, which you have to straddle to have a successful agreement.
Very interesting point, Riva. What I figured out and what I've over the years, every family is different. Each circumstances are different. That's very important to note. So what will apply to a family where the child is 1 year old and a family where the child is 17 years old, where the father and mother lives in two different homes? It's totally different, and the mediator would have to obviously take cognizance of that and deal with the matter accordingly. So therefore, I'm with you 100%. It's very hard and difficult for you to box each situation or each mediation situation into one scenario, into one box. So that obviously is impossible. But I can vouch with, and whoever's watching this video, I can vouch that mediation is a very effective tool in family law matters. Because what generally happens is you get lawyers on board, the matter takes 2 or 3 years to resolve. Had they gotten a mediator on board earlier on, they could have resolved, maybe they could have resolved the divorce, or maybe can contact issues, for example. And then later on, we can resolve the maintenance matter in the maintenance court. But the parties can get divorced, at least for now. They can move on with their lives to a certain point. And we can deal with the change later on. There's a few questions we dealt with last week. I will just pose those questions again, and we can unpack it and take it from there. So the first question was, my husband and I no longer living together. We both moved on with our lives. Our daughter lives with me most of the time. She's 15 years old. I want to relocate to Australia. Would mediation help, or must I go to court? So, Riva, please, this is the first time I'm asking you this question. How will you deal with such a situation? Relocation in mediation matters.
So, mediation can work in relocation matters. Again, like I said at the beginning, in any mediation, both parties have to be willing to work together. They both have to be willing to be there and to try and to try and find a solution. You know, the reality is that our courts there is strong precedent to allow a what we used to call the custodial parent permission to relocate. So if, for example, in this case, if mom has solid reasons for why she wants to relocate, then and dad is saying no. I mean, it's understandable. You're asking your father to give up seeing his child as often as he normally sees them. We don't know anything about the financial situation between the parties. All of that comes to bear. So I would still, in that situation, I would recommend that the parties first try mediation. If the mediation is unsuccessful, then they can litigate. Litigation is always there. The courts are always available. It's not like once you mediate, you're done. If the mediation, for whatever reason, is unsuccessful, if it's successful in part but unsuccessful in other parts, you can take the unsuccessful part, take that to court if necessary. So I don't see any reason why a relocation matter could not be mediated. Having said that, there are very difficult mediations because emotions run very high, and you would want to look for a very experienced mediator in that sort of matter.
Riva, is almost, for example, if I may use this example, if you got a cold, it doesn't mean you have to go one time to the lung surgeon and you must do a lung operation on you. Sometimes there are other things you can do. Take a tablet, do some massaging, and that's where mediation comes in. You can resolve the problem without any, aggressive medical procedures. So it does not mean that I got a rash on my body and all of a sudden go to a dermatologist and do some skin grafting, all those things. It doesn't mean that. There are alternative things to do. So the same way with family disputes and etc. It does not mean that we have to now, go to litigation and fight this whole matter out and litigate it. So no, thank you very much for that. So wonderful. The second question is, thank you very much for allowing me to pose this question. I tried mediation and it did not work. The mother is adamant that contact should be supervised despite I never having an issue. It never had been an issue when we were living together. Sorry about that. We are not married, but I feel that the law is only on the mother's side. What can I do? Did you get that question? But the mother now on supervised contact, it was never an issue while they were together. They're not married. What can he do in order to get unsupervised contact? Would mediation work?
So I think he says the parties tried to mediate, but it was unsuccessful.
Yes.
So you have to look at why the mediation was unsuccessful. If the mother has taken a strong position and is absolutely adamant that she will not move from that position, it might be that the only thing available to this man is to actually approach the court. And I know that there still is this perception the maternal preference rule is still alive and well. But the reality is it isn't. And fathers are being recognized as being very important in a child's life. And a child has a right by law to a relationship with both its parents. So I think in a situation like this, if there was a bona fide attempt to mediate and that mediation failed, then unfortunately that gentleman is going to have to go to court. I can't see how, they might try another mediation with a different mediator. That might help. Sometimes the mediator, just didn't gel with the parties. So, again, try mediation again. If it doesn't work, either go to an attorney if you can afford one. But otherwise, this is what the children's courts are there for. The children's courts are there as a form of, for access to justice. It's so that people can approach the courts directly, in situations where they may not have the money to get lawyers, to go to the High Court, etc. And if the mom is really adamant, then yeah, it could very well be that the only option available to this gentleman is to litigate.
Yes, and with litigation comes high expenses. And as you mentioned earlier on, it's no longer in your hands. It's in the hands of the courts, of the other lawyers. She might have also bulldog lawyers that just want to make money off the whole matter. And they also do not want to, take a stance on the potential of mediating matters. They just want to make some money. So that's also very, very interesting to note. Okay, thank you for that.
Absolutely. And the other thing to remember also is that, the wheels of justice turn slowly. So even in a children's court, matters can take well over a year to finalize. And if you've got a child who's who's an infant at the time that this all starts, and the parties don't manage to mediate and it has to go to court, by the time it's all resolved, the child could be 2 years old and has never even seen his father. So, you have to look also, at those costs as well, and the emotional toll that litigation takes. I mean, you and I are both very aware of it, but, by the time you get to the end of a trial, the attorney, the advocate, the parties, everybody's exhausted. It's emotionally draining. It's difficult to sit there in court day after day, the concentration, the mental exertion, so where possible, where you can prevent that for yourself, and protect yourself from that level of exhaustion, why would you not?
Riva, that's very interesting what you're mentioning now, and I'm thinking about all the time. It's gambling, honestly. Taking your matter to court, either it's frivolous or, especially a family matter. The reason why I'm saying so is if you knock into my car, and there's a witness, and we saw you knock into my car, it's simple. I get do an assessment, find out what the damages are. Simple. So the question is maybe is it 10,000 or 11,000 rand? That's the question. But whichever the matters are concerned, you might have a judge that has a preference towards the child being with a mom, or his own history, his own background, where he or she feels that I do not like mothers that are 19 years old, as opposed to fathers who are mature, that are 30 years old. And I prefer giving the child to the mature father. I don't like young girls being having kids. So those are things that possibly happen because judges are humans, and judges do not watch other judges perform in court, or they got their own courtroom and they got their own ways of dealing with matters. So you are taking a risk. You do not have any guarantee that the court would find in your favor, despite how good your advocate is, your attorney, whatever the case may be. It is possible that you might be unsuccessful.
Exactly. And I think that's really important for people to understand, is that at the end of the day, our judges do the best that they can. And our magistrates do the best that they can, but they are human at the end of the day. And the reality is on the ground, and you and I both know this, that injustices are done in court. A judge might make a decision that you feel is completely unjust for your client.
Yes, and that happens quite often, where the court makes a decision where you clearly can see that justice is not being met over here because of the court's prejudices. And it happens, especially, I'm not putting any judge now, but generally it would be like a very old judge might look down on a very young mother or my young father, and he might have certain preferences and believe no, this should happen. Or maybe Riva, you can maybe help on this. The court might have a total different view. The court might say, I don't think mom or dad is fit to look after the child. I want social welfare to come on board. And that can happen where you are fighting a matter in the court, and the court thinks, neither of you are fit enough. Get social welfare on board, get a family advocate on board, put the child in foster care because neither you or mom, but that could have been avoided should you not have come to court.
Yeah, no, exactly. I mean, there is that risk as well. There are lots of risks in litigation, which are not present in mediation.
No, wonderful. Let us deal with the third question. I have been in an abusive relationship for many years. After we got married, he started drinking and getting out of control. I want a divorce, but I cannot afford a lawyer or a mediator. What options do I have? So the question is, are there any, not free mediators, but are there alternatives to pay mediators? That is basically the same thing.
So there's an organization called probono.org, which as far as I'm aware has got offices in all major cities. They will assist you with mediation. The Family Advocate's Office will assist with mediation of a parenting plan. Beyond that, it's worth reaching out to the organizations and finding out if they have any mediators who can offer mediation on a pro bono basis. I do want to say, though, that very often in cases of abuse, mediation is not always going to be possible because of this massive imbalance in power. So there are a lot of mediators who will not mediate divorces where there is domestic violence. So it's just something to bear in mind as well. You want to make sure you're with someone experienced or someone who can really assist you in moving forward. And in a situation like that, where there has been domestic violence and abuse, very often a shuttle mediation is more effective, because sitting in the same room with your abuser can be incredibly difficult for the victim. How do you assert yourself when for your entire marriage you haven't been able to? So there's a lot of things to play with, but I think the bottom line is that it's worth contacting SARM or FAMAC. I'm not sure who deals with mediations in Natal, to be honest. But I mean, I'm sure a Google search will bring something up. And then, yeah, see if you can find someone to do a pro bono mediation.
Riva, thank you very much for that.
Pro bono.org do amazing work. They really do.
And my view is, the moment you get people in the same room together, that is where the magic happens. And you have a mediator as an umpire, where usually what happens is whenever the male speaks, the female is the one that keeps on, keep going. Or when the female speaks, the male is the one that keeps on going. And none of them gives each other opportunity to actually to listen to each other. That's unfortunately very problematic. So when it comes to mediation, you have somebody in the middle stipulating, "Sir, please keep quiet, the lady is speaking. And once she is done speaking, then you can speak." And the same over there. So it might have a scenario whereby the parties never once sat on the same table together, listened to each other for the last 3-4 years. And that actually happens at the mediation table. So that's wonderful. So the fourth question is it possible for my daughter to partake in the mediation process? She is 14 years old, and I feel that she can give her say on the issue of where she wants to live. Is it possible? Okay, this is when kids can get involved in mediation matters.
So absolutely. And in fact, sections 6.5 and section 10 of the Children's Act make it very clear that in all issues relating to children, which would directly relate to the welfare of children or the contact of care, anything relating to children, the voice of the child must be heard. And there's a number of ways of doing this. The one is, if the parties are mediating let's say, for example, a parenting plan, or even a divorce agreement, and the mediator is a trained social worker or psychologist, they may be able to bring the child directly into the mediation just to hear the child's voice. Yes, a 14-year-old's voice is going to be serious. So a 14-year-old's voice will be taken seriously, but they must be heard. Reason must be that child must be brought into the mediation, either through talking to the mediator directly, or through a voice of the child interview with a social worker or psychologist trained in this area, who can then give feedback to the parents and the mediator. But I mean, absolutely, that child's voice must, in fact, all children's voices must be heard.
Riva, thank you very much for that. And I agree with 100%. Children has a special place in our society. I mean, many judgments, confirm that all the time. And if we do not look after our children, I mean, how can we, guarantee a good future for the country? So when it comes to a child's decision regarding a minor child, we need an input. We need to know what does she want or he want. What is his views? It might be valid, it might be invalid, but at the end of the day, the voice of the child must be, given heed to. So thank you for that. And the last question now, okay. Let me get to the last question. Where do I find a divorce mediator in my area? All the lawyers here know each other. What advice do you have for me? I live in a small town and want to get divorced ASAP. Okay, I know you touched on the other organizations, but do you want to comment on this issue regarding where people know each other?
So the reality is that the industry is fairly small. So your chances are that your attorney is going to come even in a litigation matter, is going to come up against someone they know, someone they have a good relationship with. That's just the nature of the work we do. I might brief you in one matter, and the next matter I get, you're my opponent. So parties need to bear that in mind, that as attorneys and as legal practitioners, attorneys, advocates, we are trained to be able to set aside any personal feelings we have for the other legal representative in order to represent our clients. Having said that, if there is a concern around not being given a fair mediation, by a mediator not being able to be truly neutral, then especially since COVID, mediations can happen electronically. I mean, I have done many a mediation recently, thanks to COVID, over WhatsApp and WhatsApp call, video, over Zoom, Microsoft Teams, whatever happens to be available. And the other thing is, how far is the nearest town? So who says you have to use someone where you are? If you've got another town, a 20-minute drive, go down there. Look on the SARM website. So SARM is for, I think a lot of mediators. So SARM accredited mediators in, I think, Gauteng and Northwest, and I'm not sure where else will be on the SARM website. In the Western Cape, there's FAMAC. They also have a website with a list of mediators. So you can start off there and see if you resonate with anybody, and then and then take it forward. But it really does, the fact that it's a small town doesn't necessarily mean that you're not going to get a good attorney or you're not going to get good representation.
No, there are quite good legal representatives in small towns. I mean, I'm certain it's advantageous to make use of a legal representative in your own town that understands the dynamics of the court, the magistrates, the procedures, and so on. Riva, that's our 30 minutes. I think we've done extremely well today. This was so exciting. Unfortunately, it was take 2. We'll have a discussion later on regarding what topic we'll deal with next week regarding family law, and quite a few questions that can be posed regarding that. Riva, I think the take home here is clearly, don't litigate, mediate. First, try to resolve this matter outside the court. Don't go one time for heart operation. Don't go for a heart transplant. First, go to a GP, sort out the matter, try some therapeutic, go do some yoga, do some relaxation, go for some walks. Then, worst case scenario, if nothing works, then we start doing with the heart transplantation if the other stuff does not work. So the heart transplant would obviously be the litigation part of that. Do you have any final words about yourself? How can they get hold of you? I see your details are below there, your telephone number, your email address, and your website.
So it's best to email me. I'm most accessible on email. My email address is rlange, RLANGE, @rlattorneys, one word, .co.za. Otherwise, my number is 087 135 3030. And my website is live and also got all my details on my website.
Wonderful. That's all on the screen below you on your video. And your website, www.rlattorneys.co.za. Wonderful. So please get hold of Riva. She operates nationally. I do not want to say internationally at this point, but nationally. So if you have a legal problem,
internationally as well.
Of course, but hopefully international people are watching this video as well. I know some people from the States and the UK also watch this, expats and so on. So wonderful. Riva, thank you very much for your time. It's very useful, very informative. It's nice when legal practitioners can give data out there. Many people believe that lawyers are aloof, that the knowledge that they hold is complicated and like cryptic. It's not like that. It's very simplistic. We're dealing with human beings here. So all that we need to do is give you the right direction, tell you what's right, what you should do, and Bob's your uncle. You can sort out your own problems. So we're here to guide people. We're not here for you to make use of our service. We can't service the whole country, but with a little information we can give you, hopefully it can assist you with your attorney, with your advocate, on your own, to guide you better in finding those specific results you want. Riva, thank you for your time. Stay online quickly. Let me end this video quickly. Let me end the broadcast, and I'll chat to you shortly. Thank you very much. And to all the watchers, all the viewers.
You.
Thank you.